case is Westfield Township versus Kratzer. Everyone's present, ready to proceed, even though we're just a couple minutes early. Each side will have 15 minutes, and that includes the appellate cross appellants who will only have 15 minutes to present the argument. And then the original appellant will have 5 minutes to rebuttal. Thank you. If you're ready to proceed, the court will hear the argument. Thank you.
May it please the court, my name is Todd Hunt. I represent the Kratzers, Timothy and Linda Kratzer, the property owners in this case. I'd like to reserve 3 minutes for rebuttal.
Thank you.
And with me today is Timothy Kratzer, sitting back here. And not to be dramatic, but today is really a culmination of about 8 years that the Kratzers have been attempting to get some economically viable zoning designation on their property, either through rezoning or through a variance request. The property is currently zoned rural residential, but the first 500-foot depth along Greenwich Road to a length of 180 feet is zoned for local commercial. There's very little local commercial actually on Greenwich Road, even though 500 feet on both sides are zoned for that. And there's a reason for that, which I'll get to. The Kratzers purchased this property in 2000 from Mr. Kratzer's mother and took a substantial mortgage on it, but the property's been in the Kratzer family since 1917. So they've been farming there. In 2006, the Kratzers could no longer support economically dairy farming on the property. And so they were also at that time approached by developers because of the situation that the property is in. And I have brought a couple of small exhibits. These were exhibits in the record before the Board of Zoning Appeals. Exhibit 9, which is an aerial photo. And I don't know if you saw it in the record, but it clearly shows the 2 interstate highways that border this property and US Route 224, which Interstate 76 turns into, and the ramps that are there for getting on and off the interstate. And here is another exhibit from the Board of Zoning Appeals, which is a zone map for that area. And the property is hashed in green, and you will see over here in red is highway commercial. And at that intersection of I-76 and I-71 are lots of truck stops, fast food restaurants, gas stations, etc. And here's the local commercial zoning, very little of which actually has any type of local commercial on it at this point. There's no sewer or water service to this property, and to be able to use this property in an economically viable fashion, water and central sewer need to be provided to that property. The evidence in the record is that would cost about $2 million to bring those utilities to this property, which of course would also benefit the local commercial zoning and properties on the way to this property. 3 times the Kratzers tried to get this property rezoned through the township. In 2007, in 2008, and 2010 to some type of commercial use, general business use on 2 of those occasions. They were turned down every time by the township, and the last one in 2010, which was finally approved in 2011 by the trustees, was overturned, as the record reveals, by a referendum vote of the people at that time. And of course, under the U.S. Supreme Court precedent and Ohio precedent, referendum does not necessarily make the existing zoning legal. And we've cited that Eastlake versus Forest City case from the U.S. Supreme Court. Anyway, they were approached by developers in 2007, in 2006, to put in a destination retail, a large sporting goods store such as Cabela's, Bass Pro, a supermarket, grocery supermarket, or a hotel. But those persons who approached the Kratzers said, we will not touch this property unless the zoning is changed. We're not going to put a purchase agreement on it. We know how the township has been with respect to the zoning on this property, which has continued since the first zoning application in 2007, and that is the zoning would be turned down. The Kratzers then filed a use variance application with the Board of Zoning Appeals in 2013, several nights of hearings, and 3 expert witnesses, and 2 of the expert witnesses, an appraiser, Mr. John Emig, and land use planner, George Smerigan, actually looked at the property, studied the property, and came back and said the only viable use of this property is a mixed-use commercial, similar to and like the general business zoning that had been approved by the trustees 2 years earlier, but it had been overturned by referendum. And the beauty of that request for general business use variance zoning was that in that zoning text, there are conditions for all of the uses, very detailed conditions for those uses. And we were only asking for that particular type of general business use to be put on this 105 acres and not the surrounding properties, as was part of the rezoning request in 2010, which was 190 acres. We are asking the court to take a look at this and say, first of all, the lower court's remand to the Board of Zoning Appeals was in error. We did not raise any issue of procedural due process, even though we raised the issue of the obvious bias of 2 of the members of the Board of Zoning Appeals. We raised it for the purpose of discrediting any evidence or findings, particularly findings, that the Board of Zoning Appeals put in their decision that supported the denial of the variance, which was a 3-2 vote. And so we're asking the court now, and for purposes of judicial economy, to exercise your authority under Appellate Rule 12 and decide this case on the merits based on the evidence that is in the record for those variances.
I just have a question. You said you didn't raise procedural due process, but I'm not sure how you raise the bias of a hearing officer and not in essence raise, or not just in essence, but directly raise that the proceedings weren't fair, which is the heart of due process, isn't it?
Well, first of all, I think the proceedings were generally fair because we got into evidence everything that we needed to get into evidence.
But you don't have a, for better term, a trier fact or a tribunal that's fair in assessing that evidence.
Well, that's correct, but we were asserting only that the court, the lower court, should discredit any kind of findings on any evidence that were not sufficient for the record. Because it wasn't fair, but we did not raise a procedural due process claim under the Constitution, and we specifically, in our assignments of error, did not say that there was a constitutional violation here.
So what was the court to overlook that issue? If the court reviewed the transcript and I think made some pretty specific findings about the involvement of the members of the board that, you know, the court determined were absolutely antagonistic to the position of your clients, how could the court ignore the due process clause?
Our position is that the trial court had to look at the evidence in the whole record and determine whether the decision of the Board of Zoning Appeals to deny the variance was supported by substantial, reliable, and probative evidence. And so we raised the issue that the findings that the board came up with were not reliable, probative, and substantial evidence. So we were discrediting any evidence or findings that the BZA came up with, but not necessarily discrediting the fairness of the proceedings by the fact that we had put in substantial overwhelming evidence to support our variance request. So that's the fine line that we're
If I may,
presenting.
aren't you simply asking the trial court to make a decision?
Yes, on the
Simply
merits.
make a decision on the
And I
merits.
think we're asking you to do that because I think you do have the authority under Appellate Rule 12. Townships are creatures of state statute, and their authority for variances is under Revised Code 519.14b, which authorizes variances from the terms of the zoning resolution as will not be contrary to public interest, owing to special conditions, literal enforcement of the zoning will result in an unnecessary hardship to the owner, and so that the spirit of the resolution, the zoning resolution, shall be observed and substantial justice done. The township has admitted in its brief that there is no bright line rule in Ohio. And where do we draw the line with respect to use variance requests versus legislative action? And we would submit that the township zoning resolution itself, in section 202B, sheds a lot of light on why the zoning board had the authority and should have granted our use variance request. That provision deals with prohibited uses, which says any use which is not specifically listed as a permitted use or as a conditional use for one or more of the zoning districts, or which is not otherwise interpreted and approved as provided by this resolution, shall be prohibited. A prohibited use shall not be established in any district, except, and here's the key language, except pursuant to a use variance approved by the Board of Zoning Appeals. The essence of a use variance is that you are asking for a use that is not permitted in the zoning district. And the township's brief is replete with language. I think they think that if they say it over and over enough, that it'll become a principle of law, that the zoning variance being requested must somehow comport with the existing zoning on the property, which is rural residential. And the Board of Zoning Appeals itself found that that was not viable. And the local commercial, which all the evidence supported, was not viable either.
And you're going to be entering your rebuttal.
So just to conclude at this point, we feel that the Board of Zoning Appeals had the legal authority to grant our use variance. In this special circumstance, it was a perfect scenario for the Board of Zoning Appeals to grant a use variance because it laid out all of the standards and conditions for the variance in that text that was submitted with the application. And in fact, the board in the zoning resolution does authorize the Board of Zoning Appeals to put supplementary conditions on its grant of a variance at resolution section 906B. Thank you.
Thank you. If it please the court, counsel. My name is Mike Lyons. I'm an assistant prosecutor with the Medina County Prosecutor's Office, and I'm here on behalf of Westfield Township. And I would begin by saying that the Board of Zoning Appeals has limited authority. It's a statutory animal, and its authority to grant a variance is tied to the zoning code itself. It does not have authority to legislate zoning regulations. It does have authority to grant variances, which includes both area variances and use variances. But those variances are part of the process of enforcement. And if we look at the section cited by counsel, 519.14b, which gives authority to grant variances. It allows the granting of variances owing to special conditions from the literal enforcement of the resolution. So even in the grant of authority to give variances, it is in the process of enforcing the zoning code that the BZA exercises its authority. So in the exercise of its authority, it is tied to the code itself. And that principle is repeated over and over again by the courts related to variances. Now, council has cited the Eastlake case, and the in the Eastlake case, there was a challenge to the use of the referendum process in the legislative process. And the U.S. Supreme Court upheld the use of a referendum as part of the legislative process for zoning regulations. So that case actually supports the history of what has happened here, because the court there held that the people were reserving to themselves the right in this legislative process to approve or deny a zoning change. In this case, the request for a variance, and I would ask the court to look at the application for a use variance, which is in the record, and I'm going to read what that request says. Request is to vary zoning regulation section 303B, permitted and conditional uses, to permit the uses that are permitted and conditionally permitted in the attached Exhibit A at the subject property and under the standards and conditions also set forth in Exhibit A. And attached is section 308 Business District, which is not a district that exists in the zoning code. It is the same text that was the subject of the zoning amendment process that ended in the most recent iteration with a referendum that rejected that zoning change. So the nature of the variance that's requested is not a specific use on this piece of property. The request is to adopt the same zoning regulations that were the subject of the amendment process and apply that to this property. So I would ask you to take a close look at the consequence of granting this variance.
Well, your position is that the BZA does not have the authority to do so.
Exactly, yes. And it doesn't have authority because of the extent and nature of the variance that's requested, without regard to the evidence that may be presented. The requested variance is so fundamentally legislative that there can be no evidence presented to the Board of Zoning Appeals that would give them the authority to grant this relief. It is not within their authority. They're not competent. So that's essentially the argument. Now, I quickly looked through many of the cases that were cited, and I think if you look at those cases, you will find that in all of those cases, the relief requested was in the case of a use variance, it was a specific use, something like selling cars and tires, or a residential building on a light industrial lot. They were very specific requests that had a very limited scope, and the BZA was competent to consider those kinds of requests. But the relief requested in this case is qualitatively and quantitatively unprecedented in any of the cases that we see. They are asking the BZA to approve a new set of regulations. Not only adds a new list of potential uses, but also has separate and independent area requirements, building size requirements, lot size requirements. So this is not merely a use variance. This is also an across-the-board change in all of the area requirements for this property. So I believe if you take a close look at the relief that's requested, it cannot be argued that this is within the authority of the BZA to consider. So it is our position that the BZA does not have authority, and this court would be in a position to rule on the fundamental issue of the jurisdiction of the Board of Zoning Appeals to even hear the case. So we would ask you to also overturn the ruling of the lower court that remands it back to the Board of Zoning Appeals and dismiss the case on the grounds that the Board of Zoning Appeals does not have authority to consider this as a variance request.
Thank you.
Thank you.
We actually have 2 minutes and 6 seconds.
Thank you. First, I want to say that all of the uses that are requested in the general business district are actually uses that are permitted currently in the zoning resolution in other districts. That's the essence of a use variance request, is that the particular uses in a zoning district are not viable. You can't use the property for those uses, so you look elsewhere for a use. And that's not confined to the current zoning resolution. But I would point out that 9 of the 11 permitted uses in the text that was supplied with the application are currently in the zoning resolution, except for movie theaters and other types of theatrical places of venue, and except for apartments. The other thing is the only exception on the retail, and there's retail permitted everywhere in the current zoning resolution, is the square footage of the buildings. And so obviously what our experts testified to was you had to have a large retail building to be able to economically use this property and to bring the water and sewer to that property to be able to economically and viably use that property. Otherwise, you're confined to farming it, which is not, in this instance, my gosh, you couldn't even grow soybeans, the testimony was, because of the too much light from the highway 24/7. The other thing is my client was really on the horns of a dilemma here. He's trying to sell the property for a use. The only viable use and the only takers of the property have been those who want to develop it for retail, large retail, and the associated smaller retail that comes with that, number one. Number two, we can't get anybody to make an offer on the property because of the zoning history with the township. And so he wasn't able to come forward with one specific use for one user for a use variance. And what he gave was something that was very, very, I think, amenable to a use variance, because
You need to wrap it up.
in lots of cases with a use variance, you don't have specific regulations for that use. So we would ask that the court reverse the remand order below and actually move forward and decide whether the variance should have been granted in this case.
Thank you. Thank you to both of you for your presentations. The court will take the matter under advisement. We'll issue a written opinion that will be sent to both sides, and you can check on our website as well. Thank you. Thank you for coming to Akron, and enjoy the rest of the day.